Hello and welcome back to our special lecture series on the subject of constitutional law. My name is Taimur and I'm an attorney at law. So today we are going to be covering the famous case of Nawaz Sharif versus the President of Pakistan. A case where the government of Nawaz Sharif was dismissed along with his cabinet pursuant to an order issued under Article 58(2)(b) by the then President Ghulam Ishaq Khan. In our last lecture, we covered the case of Khwaja Ahmed Tariq Rahim, in which the government of Benazir Bhutto was similarly dismissed pursuant to the same order issued under Article 58(2)(b) by the same President Ghulam Ishaq Khan. And it was done so on grounds namely that the utility and the efficacy of the National Assembly had been defeated by internal dissensions, tension, because of government's inability to substantially pass laws. Apart from the adoption of finance bill, they had not been able to pass many laws, and due to other reasons such as corruption, nepotism, horse trading, the fact that there wasn't much of cohesion between the federation and the provinces, the government of Benazir Bhutto was dismissed. And the criteria which was given pertaining to Article 58(2)(b) was that the power to dissolve the National Assembly is an extreme power, and it is to be exercised only when there is an actual or an imminent breakdown of the constitutional machinery, as distinguished from failure to observe a particular provision of the Constitution. That there may be occasion for exercise of such power where there takes place excessive, continuous and pervasive failure to observe numerous provisions of the Constitution, creating the impression that the country is governed not so much by something constitutional but by something extra constitutional. Now, one of the most noticeable things about this case was that this ruling was given by the Supreme Court by a majority of opinion of 10-2, but initially this case was brought before the Honorable Lahore High Court, and the Honorable Lahore High Court, wide order dated 14th of October 1990, gave its verdict, whereas the general elections were required constitutionally upon the 24th of October, which was just a few weeks after the decision of the Lahore High Court, whereas the Lahore High Court decision was now challenged and an appeal was filed before the Supreme Court, which was through a short order decided in the month of November 1991. So this whole process somewhat underscored or brought out an inherent flaw, that by the time the decision of the Supreme Court would come out, elections would have already been held. And the dictum of Haji Saifullah would apply, that the Honorable High Court, in exercise of its constitutional jurisdiction, may not issue the discretionary remedy of writ of mandamus if it would not serve the public interest. And so, in fact, through the time delay aspect, the whole remedy of Supreme Court would become infructuous, which was certainly the case in Khwaja Ahmed Tariq Rahim. Now, proceeding further, the elections were held on the 24th of October 1990. IGI, a party that was being led by the President Nawaz Sharif, secured some 106 seats, whereas the Pakistan People's Party came in second. But IGI managed to secure more seats and therefore formed government. Now, there were some concerns about how the 1990 elections were held. There were concerns about financial irregularities, and in the year 2002, the Honorable Supreme Court of Pakistan, in the famous Asghar Khan case, also said and held that there were certain elements, there were certain individuals from Pakistan army and intelligence forces who were involved in funding certain political parties, which further reinforces the already held belief that the 1990 elections were anything but fair and transparent. Now, rolling the clock forward, on the 18th of April 1993, the government of Nawaz Sharif was dismissed on grounds namely that there had been mass resignations given and tendered by members of the opposition, including some from the treasury benches and including certain ministers. Furthermore, there was a speech which was given by Mian Muhammad Nawaz Sharif on the 17th of April, just one day before this dissolution order, which was construed as having been a form of giving an agitation, that this constituted a form of subversion of the constitution. And there were other form of grounds which were given, that in constitutional institutions such as the Council of Common Interest, the CCI, National Economic Council, they could not perform or discharge their duties constitutionally, that security situation required further attention, and many of the other different grounds were given in the dissolution order. Briefly, the facts of this case were that there were a great number of meetings that took place between the Prime Minister and the President in the months of March and April in the year 1993. The last meeting which was held between them was done so on the 14th of April, where the President urged the Prime Minister to take effective steps to control the law and order situation in the country and other problems that were prevailing at that time. However, on the 17th of April, the Prime Minister addressed the nation and raised a great number of allegations. And they were perceived by the President as somewhat being targeted at him, that a great number of conspiracies were being hatched, that his government someone was trying deliberately to dislodge his government. And a special session of National Assembly was now called in session to be held on the 19th of April 1993. And now certain historians believe that initially on the 14th of April, when the President sat down with the Prime Minister and urged him to take certain steps, he actually had asked the Prime Minister to get rid of some of his most loyalist ministers. Initially, Nawaz Sharif perhaps didn't give an answer or agreed, but on the 17th, when he addressed the nation in a defined manner, his tone was very clear that he had sent a signal to the President that he would not be dictated upon. And when the special session now was called in a hurried manner for the 19th of April, the President somewhat felt threatened that maybe an impeachment motion may be moved before the National Assembly. And therefore, in order to preempt this, because in the morning of 18th of April 1993, Benazir Bhutto had come to the President, and she had handed over resignations of many members from the opposition over to the President. And so in the evening on the 18th of April, the President simply dismissed the government of Nawaz Sharif through this order issued under Article 58(2)(b). Now, in the aftermath of the dissolution order having been issued, the Prime Minister, the petitioner in this case, instead of going before the Lahore High Court and making the same mistake or meeting the same eventuality as was met in the Khwaja Ahmad Tariq Rahim case, he chose to invoke the original jurisdiction of the Honorable Supreme Court in the first instance, bypassing the remedy of the High Court. Now, there was a problem, because the original language, if anyone wishes to invoke the constitutional jurisdiction of the Honorable Supreme Court, Article 144(3) stipulates that firstly there has to be a question of public importance, and B, it must bear reference with enforcement of any of the rights provided in Chapter 1, Part 2. So even though this may be considered as a case of public importance, but no fundamental rights seem to have been infringed upon. And so the learned Attorney General initially took up his preliminary objection that no fundamental rights have been infringed, that Article 17, which provides that every citizen shall have the right to form a political party, only means or extends to being a member of a political party or forming a political party. And so there are other provisions provided in the Constitution, for instance Article 51, which provides for election by direct and free vote to the National Assembly. Article 91 provides for formation of the National Assembly, read with Article 52, and Article 58 also provides from where the tenure of National Assembly could be circumscribed. So since these provisions, the question of completing the tenure already stands covered under other provisions of the Constitution, this would not be considered as a fundamental right. S.M. Zafar also joined in, and he argued and he submitted that the fundamental right provided under Article 17 extends to the point of contesting the elections. At the time when once a person has been voted in office, then the fundamental right comes to an end, and it transforms into a political right. And he drew a distinction between a legal right, a constitutional right, and fundamental right, and based on his submissions, no fundamental right had been infringed. The fact that the petitioner wants to state that I should be allowed to complete my 5 years, my whole tenure, and if even 1 year has been let go of, my fundamental right would have been infringed. However, the Honorable Supreme Court firstly delved back in time and they reviewed certain earlier cases where similar questions had arisen. One of the first cases was Maulana Maududi case, in which Jamaat-e-Islami was banned outrightly, and the High Court in East Pakistan had given an order in their favor. The case made it all the way before the Supreme Court. Even though the case was dismissed in favor of Jamaat-e-Islami on violation of principle of natural justice, the principle was laid that the right to form a political party also means that there must be a right to carry the activities of a political party. In Benazir Bhutto Election Commission case, they went one step further and they said that the right to form a political party also extends to the right of the political party to continue its activities apart from carrying out the activities. And furthermore, in the civil case, the Supreme Court said that it also includes the right of a political party to contest elections under its banner and under its symbol. And so there are certain consequential rights that would follow through. The Honorable Supreme Court said that Article 17 also extends to a right of a political party to form a government if it possesses the majority in the Assembly. And if any order frustrates such from happening, then it would be construed as a violation of the fundamental right. And so they held that this would nonetheless be construed as a violation of fundamental right, and so the petition is maintainable. One of the grounds which was taken up by the petitioner was that the Article 58(2) Order B read that this power to dissolve the National Assembly has been driven from Article 58(2)B and all other enabling provisions. And the Supreme Court said that this is not like the Crown exercising its powers, that it may have some residuary powers. The Crown can do no wrong, it cannot be removed, and that parallel could not be drawn, which perhaps may be the case when the Constituent Assembly was trying to frame the Constitution. Now that we have a written Constitution, nothing has been left to surmises or conjectures. The President has fixed powers, and only those powers which have been given to him under the explicit provisions of the Constitution, and no powers apart or other than them. Now, one of the grounds, the main ground which formed basis of the dissolution order was that there were so many members who had tendered their resignations. There were some 88 members, and including certain other members who were on vacancies, the number stood even beyond 100. But the Honorable Supreme Court referred to Article 64, and the respective provision was that if any member wanted to resign from his seat to National Assembly, he must do so in writing in a letter addressed to the Speaker or the Chairman, as the case may be, and the rules were formulated as form of delegated legislation. The Rules of Procedure and Conduct of Business in National Assembly Rules 1992, Rule 25 stipulates that if a person hands over his resignation by himself in person, then the Speaker at least would see that this is voluntary and he has no other information apart from this to suggest otherwise. Or if he has received a letter, then he has to be satisfied that this was voluntary. And so unless the Speaker first carries out this inquiry, no legal effect as such can be given to these resignations, and it could not be made a basis for issuing the dissolution order in the first place. The second ground, the main important ground which was given, was with respect to the speech which was given by Mr. Nawaz Sharif on the 17th of April 1993. The Supreme Court said that there were certain rules. The High Court, the High Treason rules of 1973 were framed, which stipulated that a person can be found guilty by a court of competent jurisdiction, and it has to be firstly authorized by the federal government. And Mr. Shafiur Rahman, who wrote the majority opinion, also said that to suggest that this speech in itself is subverting or is a form of subversion would go against Article 14, which provides that the dignity of man is inviolable, and this is also a fundamental right. So even if, for the sake of academic discussion, we were to conclude that Article 17 does not extend to a government or to a political party to complete its tenure, on this very basis even Article 184(3) jurisdiction could be invoked. and that unless he has been pronounced guilty by a court of competent jurisdiction, it would affect prejudice to his other rights as well as to Article 14. Now, there were other sort of generic grounds as to whether the CCI and other constitutional institutions had been discharging their constitutional responsibilities in letter and spirit, but the court said that these grounds were way too subjective to hold whether they would support the dissolution order. And after examining all the respective grounds, the Supreme Court, in a ruling by majority by 10-1, held that the order issued by President Ghulam Ishaq Khan under Article 48(2)(b) did not meet the criteria, and as such the order was set aside and the assemblies were restored back to their order by orders of the Honorable Supreme Court. Justice Sajjad Ali Shah was the only judge who gave his dissenting opinion in the Nawaz Sharif case, whereas all the other judges agreed with Justice Shafiur Rahman in his majority opinion which was written, and the opinion was 10-1. Justice Sajjad Ali Shah was that one. And Justice Sajjad Ali Shah in his opinion wrote and held that in terms of maintainability of this writ petition, he did not agree with the other judges. His take on the matter was that the fundamental right as provided under Article 17 would extend to the point of forming a government. Once the government has been formed, for it to complete its tenure would be more of a political wish, a political right, than a fundamental right. And he also concurred with what had been already submitted, that there are other provisions which deal with the completing the tenure of the National Assembly, with the formation of the national government, and so a fundamental right as such would not be violated. And on this basis he held that this petition should not have been even maintainable in the first place. On merits, he held that we should apply the same standard in Khwaja Ahmad Tariq Rahim as we now should do in the Nawaz Sharif case. You see, in the Khwaja Ahmad Tariq Rahim case, the government of Benazir Bhutto was dismissed on grounds of defection, horse trading, and even though there is a particular Section 8B provided under Political Parties Act of 1962, which provides that if any person defects, first this matter has to be brought by the leader of the parliamentary party to the Election Commission. The Election Commission would decide, and against the decision of the Election Commission, an appeal to the Supreme Court would lie. So unless this process has been brought within the mischief of law, effect should not be given just to an accusation given by the President that a certain someone has defected. But nonetheless, in the Supreme Court judgment in Khwaja Ahmad Tariq Rahim, effect was duly given even though their defections had not been brought within the mischief of law. Justice Sajjad Ali Shah's take was that similarly in respect of resignations, why should there be so much concern that now it has to be brought within mischief of Article 64, read with the Rule 25 of the National Assembly rules? We should apply the same principle. And in that respect, the order 58(2)(b) should be upheld like it was in the Khwaja Ahmad Tariq Rahim. Apart from this, he also talked about the speech which was given by the Prime Minister Nawaz Sharif, and he said that in his own speech the Prime Minister admitted that the situation has somewhat arisen due to conditions, due to the prevailing situation in the country, that the government as such could not be carried onwards in accordance with the provisions of the Constitution. And the speech which was being given against the President was a clear defiant act of stating that these institutions are not working, and it couldn't be any clearer from the words and from the tenor of the speech that there was indeed a constitutional breakdown of the machinery. Apart from other grounds, he touched base with all of the respective grounds which had been made part of the dissolution order, and on majority of the grounds his opinion was that this order should have been upheld. The aftermath of the Supreme Court judgment was that on the 26th of May the National Assembly was restored. However, the political reality on ground had somewhat changed, and even though the caretaker Prime Minister now had been removed, in the province of Punjab the Chief Minister at that time was now very hostile to PML and government, and they had also made deals perhaps indicating that Chaudhry Parvez Ilai would become the next Punjab Chief Minister. And on the 29th of May 1993, an advice had been tendered by the Chief Minister to Governor Altaf Hussain to dissolve the Provincial Assembly. Now this did not sit well with the ambitions of the PMLN group, and so they also had moved a resolution for vote of no confidence against the Chief Minister. And when the Assembly was dissolved, they challenged this case before the Honourable Lahore High Court, and their claim was that on the 29th of May a resolution for vote of no confidence had been moved earlier to the advice which had been tendered by the Chief Minister to the Governor for dissolution. And so under Article 112, when a resolution has been moved for vote of no confidence before the Chief Minister at the Punjab Assembly or any other assembly, then he cannot simply advise the Governor to dissolve the assembly till such time that the vote of no resolution or resolution for vote of no confidence is firstly determined. And the Lahore High Court decreed and ruled in their favour that the resolution for vote of no confidence had been moved earlier, but then after the decision was made, the Governor Altaf Hussain again decided to dissolve the Provincial Assembly. Situation somewhat had gone out of control, and under Article 234 the federal government now decided to take over control and management of the Provincial Assembly of Punjab, but they did so without having the President sign any such proclamation, which was somewhat against the mandate of the language of Article 234. The federal government argued that since both houses had agreed, we could bypass the President, which is something that didn't sit well with the President Ghulam Ishaq Khan, and tension further grew. And by the 18th of July 1993, the Chief of Army Staff brokered a deal between these two groups, whereby firstly Prime Minister Nawaz Sharif advised the President for dissolution of the National Assembly. The President complied and dissolved the National Assembly, and both of them then resigned from their positions. And so now general elections were again to be held sooner. So this was pretty much the whole case that I have narrated of the famous Nawaz Sharif versus President of Pakistan. We're going to cut short our lecture here today, and I hope that we have tried to cover most of the important provisions in this case. Thank you.